In a decision that could reshape how traditional medicine is advertised in India, the Supreme Court has closed a high-profile case concerning misleading medical advertisements. This ruling effectively allows AYUSH, Ayurveda, Yoga Naturopathy, Unani, Siddha, and homeopathy medicines to be advertised without needing prior state approval, a move that raises critical questions about consumer protection and public health. The case initially stemmed from a petition filed by the Indian Medical Association, IMA, which sought to challenge what it described as deceptive claims made in advertisements for Patanjali Ayurveda's products. These ads, according to the IMA, not only misled consumers, but also undermine trust in modern medicine by disparaging its efficacy. At one point, the court even imposed a temporary ban on Patanjali's advertisements, after finding them to take the country for a ride. However, this wasn't just about Patanjali. It opened the door to broader discussions about ethical advertising practices across industries. But here's where it gets controversial. While the court acknowledged the dangers of misleading ads, it ultimately decided to let go of the stricter regulatory framework that had previously been enforced through Rule 170 of the Drugs and Cosmetics Rules 1945. For decades, this rule required advertisers of Ayurvedic, Siddha, and Unani medicines to seek pre-approval from state licensing authorities before publishing their claims. Without this safeguard, companies can now promote treatments with bold promises, like herbal cures for chronic diseases, without proving their validity to regulators first. The turning point came when the Ministry of AYUSH issued a notification on July 1, 2024, removing Rule 170 entirely. While some argued that this brought Ayurvedic medicines in line with allopathic drugs, which aren't subject to similar pre-approval requirements, others saw it as a dangerous step backward. Critics worry that vulnerable populations might fall prey to exaggerated claims, delaying proper medical treatment until it's too late. During today's hearing, senior advocate Shadon Farasat, appearing as amicus curiae, noted that states had continued enforcing Rule 170 despite its removal at the central level. But Justice K.V. Viswanathan countered this, asking how states could enforce something that no longer existed under national law. Meanwhile, Solicitor General Tushar Mehta, representing the union government, emphasized that existing laws already provide robust safeguards against false claims. "Let us not doubt the intelligence of the common man," he remarked, suggesting that consumers are capable of discerning truth from fiction. Yet, this raises an important question. Are we overestimating the average person's ability to navigate the complex world of healthcare marketing? As advocate Pranav Sachdeva pointed out, many people remain gullible and may be swayed by attractive promises. He warned that false claims could lead patients to delay seeking professional care, potentially worsening their conditions. Justice B.V. Nagarathnam echoed another perspective, stating that banning advertisements for legally manufactured AYUSH products would amount to unfair trade practices. Once you permit manufacture, then advertisement of that product will be a natural business practice, she observed. Her comments highlight the tension between economic freedom and public safety, a debate that isn't likely to end anytime soon. Ultimately, the court concluded that all the primary objectives of the writ petition had been met through various interim orders. It vacated its earlier stay on the deletion of Rule 170 and disposed of the case, leaving parties free to approach the High Court if they wish to contest the omission further. And this is the part most people miss. What happens next? Will self-regulation truly suffice to protect consumers? Or will we see a spike in misleading claims flooding the market? One thing is certain. The conversation around ethics in medical advertising is far from over. Do you think the court made the right call? Should stricter controls return? Or does personal responsibility hold more weight in our digital age? Share your thoughts below. We'd love to hear from you.